questions that came out of class 1. I'll try to get to those. We have a lot to cover for anybody who's kind of been keeping up with the homework. We had chapter 2, domain 1, stuff to read. I'm going to turn on my video so you guys can see a face, I guess. So we had 60 some odd pages to read today. I'm going to minimize this. You guys can see me. So we had a lot of stuff. If you read the chapter, and this is all new information for you, it seems like a ton of information. It was kind of a fire hose in this, in this last homework assignment. We're going to go pretty fast. I have 60 some odd slides to get through tonight. And it's hard to really tie a lot of these concepts together. It's hard, to kind of get the relationships between everything. But like I told you in the first class, a lot of this is going to be memorization. So it's just kind of getting these core concepts down and memorizing it. And a lot of the stuff, as I went through the chapter, all the stuff seemed really relevant to me. So I don't think there's anything in there that you have to dump after you take the test. All this stuff is kind of important ongoing. So I'm going to dig through if I click the right stuff. So these are the things we're going to talk about tonight. We're going to talk about cornerstone security concepts. So we covered a little bit of that on Tuesday. I gave you 2 definitions I think that are really, really important. And you can see how they're kind of in this chapter too. So I gave you the definition of information security, my definition, which is, I think, not just mine, others too. And then I gave you the definition of risk. Now you'll notice in the book that the definition of risk in the book is slightly different than the definition I gave you. I'm going to tell you why I use my definition. I don't use the definition in the book, but for the test, let's go with the definition that's in the book. So what I've been, and I'll share just a little bit about what I've been doing, the last 3 days here in New York, working with a really good client of ours. We've been working on this definition of risk for them. I think there's a fundamental misunderstanding. So you have one part of the organization who's working off of one definition of risk, and you have another part of the organization working on another portion of risk. They're kind of both equal in the organization, and they're having a lot of conflict. They're not getting along. Now, there's other factors that go into that, but I think the risk piece is a big part of it. I'll be coming back here again in June, on June 10th, and we have a 6-hour kind of summit for these 2 groups to kind of get along and repair the relationship. And a big part of that's going to be, actually, I'm going to use a lot of the stuff that I used in the same presentation from Tuesday then. So I do apply this stuff all the time, and you will too. We'll talk about cornerstone information security concepts, some legal and regulatory issues. So we're going to get into some legal stuff. It's important to realize that we're not lawyers. I don't offer legal advice. I make sure that people know that I'm not a lawyer, but here's what I know about how legal things affect information security. Security in third parties, vendor risk management. We know about some of the biggest breaches in the world in history really have come from vendors and kind of some of the practices that they follow and how that affected the big organization. Talk about ethics. Ethics is pretty easy because most of us are pretty ethical. Ethical people don't really need to spend too much time on understanding ethics. Information security governance. We'll talk about policies, procedures, standards, guidelines, and how those things all fit and why we use them. And those are administrative controls most often. Access control, defensive categories and types, risk analysis, and some types of attackers. The types of attackers is actually pretty quick. We don't go into a lot of depth here. I'll drive through all that. So if you remember, here's my definition of information security. This is the same definition essentially that we see in the book, and that's the same one that we'll use in the exam. The 3 things that they really key in on in the book and in the exam is confidentiality, integrity, and availability. They refer to it as the CIA triad. Now, information security, administrative, physical, and technical controls, which you see later on in this chapter. But early on, it's talking about confidentiality, integrity, and availability. Confidentiality, essentially keeping things secret, restricting unauthorized access to information. Integrity is making sure that that data is accurate. They don't go into a lot of detail in the exam about data integrity, but there's really kind of 2 parts to that. There's internal data integrity and external data integrity. Internal data integrity is like in a database. We have referential integrity and those types. And then external integrity is, if my database says that I have 34 widgets, and I go out to the warehouse, do I in fact have 34 widgets? And that would be, kind of external integrity. And then we also have availability. Now it's a real big balance between the three. If I really, really lock things down, make sure that only people that should have access to information. I really focus too heavily on that. I'll probably affect availability and start not allowing people to access information when they should. So anyway, balance is super critical. The opposite of CIA, or confidentiality, integrity, and availability, sometimes referred to as the CIA triad, is disclosure, alteration, and destruction, or DAD. We talked a little bit about that on Tuesday. So I apologize if I'm going to go too fast, but we have a lot to get through. We did make the slides available from Tuesday's class. We'll also do the same thing here. Another cornerstone security concept is this thing called privacy, and privacy really is a subset of information security. It's really focusing on just the confidentiality of personally identifiable information, or sometimes referred to as PII. We should have a good fundamental understanding of information security, and this is our understanding of what.
Why what? Just take him out.
Take him out. The other cornerstone security concepts: identity, authentication, authorization, and accountability. Those 3 A's: authentication, authorization, and accountability, sometimes referred to as AAA. Identity, the first part of this, is really just professing who I am. Oftentimes it's just a username, ID number, something like that. And an identity by itself, there's no proof that I am who I say I am. That comes with the authentication. So when we do social engineering attacks, when we're posing as somebody that we're not, oftentimes we just use the identity piece. We don't ever have to usually authenticate. I walk into, well, in your own buildings probably, you walk into the building as a visitor. It's very rare that anybody asks us to actually prove our identity, give the authentication piece. That stops us sometimes, or makes it a little more difficult for a social engineer. So identity is a big piece, and they all fit really closely together. The next is authentication. That's the proof of who I am. We'll talk about the different forms here. Oftentimes it's a password. So whatever password, PIN code, picture, something like that. Now, identity without authentication is really completely useless. There's no accountability. So these things have to go together. The reason why we make sure that you don't share usernames and passwords, and the reason why we don't want you to give your password out, is we've then broken the authentication piece of this flow. So identity and authentication should be different. Now, I give an example here. One of the reasons why we have problems with identity theft is because I use the same number for identification as I use for authentication. So they should be used differently. If you want to fix that problem, you really have to redesign the entire system. So you'd have maybe an identity being your social security number, and then have something else as an authenticator. I'm going to bring up the chat in case we have any questions, because I am going kind of fast. Oop, I just stopped the sharing. All right, it's back. So if you have any questions, if I'm going too fast, speak up. We refer to oftentimes these things called strong authentication, or multi-factor authentication, or two-factor authentication. There's really 3 factors to authentication. The 3 factors are something I know, that's a username, PIN code, something like that. Password. Something I have, a token, a phone. There's different types of tokens: hard tokens, soft tokens, debit card. It would be something that I have. So every time I go to the ATM machine, I'm actually using two-factor authentication to access my account. I have my debit card, and then I also have a PIN number, so that would be two-factor authentication. Another factor is something that I am, which would be biometrics, whether it be a fingerprint scan, a retina scan, hand geometry, something like that. So 2 or more of these factors is called strong authentication or multi-factor authentication. One of the reasons why we stress 2-factor authentication, and if you look at PCI DSS, for anybody who does PCI work, they just issued 3.2, version 3.2 of the PCI DSS, and in that, one big piece is now administrators have to use 2-factor authentication to access systems, not just remotely now, but also locally. So 2-factor authentication is a big deal, and the reason why is it's really easy in a lot of cases to compromise a single factor. So we use phishing attacks sometimes to get somebody's username and password. Sometimes some people write them down. They make easy ones to guess. So if we implement a second factor, it just makes it that much more difficult to compromise an account. So identity. First I profess an identity to the system, then I authenticate to the system. The next thing I get is privileges or rights, which is where authorization comes in. This is what the system is going to allow me to do once I've identified myself and I've authenticated. Now there'll be a set of rights or privileges that are assigned to me. And it's tied back to my identity. Usually that's the piece where authentication, authorization, and accountability are all tied back to identity. So after I authenticate, I get some authorization tied to identity, sometimes referred to as privileges and rights. The next piece is accountability, which is a record of what I did when I was in the system. This comes after authentication. This is also tied back to identity. And you can see that for people that have been in information security for a while, some of this stuff seems pretty obvious. But if an attacker compromises a user account or it's a shared account and something bad happens, the things that we're going to use in the investigation to try to figure out how this thing happened is going to be log files, things like that. It's going to be the accountability pieces. Now, if it's a shared account, we'll never have the accountability back to a single subject or user. So when we have that, we have what's called repudiation. There's non-repudiation, which is the ability to prove that somebody did something in the system. Repudiation means that there is no proof. We won't be able to tie it back to a single person without any kind of doubt. So hopefully that makes sense. At this point, we've covered security, privacy, and this IAAA concept: identity, authentication, authorization, and accountability. Other cornerstone security concepts, this thing called least privilege and need to know. Least privilege is usually tied to rights, to what I can do with the system or in the system. It's usually tied to a system. Whereas a need to know is what I can do with information. So they're very similar concepts. Need to know is a little more granular because I take that all the way down to the data or the information level. Examples of need to know at FRSecure, for instance, I may be working on specific accounts that other analysts aren't working on, or I'm working on accounts and there's really no need for any of the security consultants or to ever see the data that I'm working with. We would lock that down and use the need principle to kind of drive that. A lot of the work we do might be under attorney-client privilege, and that would be strict need to know. Usually what happens is if there's a violation of least privilege, so if I have administrator rights and I shouldn't have, that leads to a violation of the need to know principle. And on that point, one of the biggest things you can do to really improve security is to remove local administrator access or administrator access and privilege rights. So everything kind of flows from there. And that's one of the struggles with an organization that we're actually working with right now is this privileged access. There's continual failures in the privileged access audits. So it is a struggle. But these are two concepts that are really important. From this kind of drives everything else. Any questions so far? We're good? Another concept, and this is where it kind of makes it hard to kind of tie all these things together because it's so kind of splattered so much information in such a short period of time. But then there's this concept of subjects and objects. A subject is an active entity. It operates on or manipulates other things. And then there's this concept of objects. So subjects manipulate objects. Subjects can also manipulate other subjects. But the point to remember is that a subject is an active thing or entity, whereas objects are passive. Now, it all depends on context. Something might be a subject at one point, and then at another point, depending upon what it's doing, it may become passive. But I think for the exam, remember that a subject is an active entity and an object is a passive entity. And when you do take the exam, use the definitions that are here, but also take into account the context for the question. Defense in depth, another cornerstone concept. This is multiple layers of defense. When we work with organizations, most organizations, if we were to use an analogy, are kind of built like a crunchy shell and a gooey center. So there are layers of defense on the exterior. Once you get into the environment, it's a gooey center. It's like a Rolo, sort of. Except for Rolo. Whereas the type of security we want to build in companies is more like a gobstopper where we have multiple layers of hardness. So if I get past the firewall, I get past the DMZ, and I'm into the internal network, are there still controls there to stop me? Is there host-based intrusion prevention? Is there network-based intrusion prevention? Is there anything else to stop me, or do I just have free reign? Network segmentation is another piece. And if you talk to penetration testers, well, actually two things that are pretty common in the breaches that we research or that we're part of. One is vulnerability management is typically terrible. So if you do get into the environment, there's plenty of vulnerabilities for you to compromise. It makes it even better if users have local administrator rights, because then you own that system and it makes it a nice pivot point into other systems. Another thing that is usually severely lacking is network segmentation. So if you compromise a system, and there's lots of ways to do it, if I trick a user into downloading a piece of malware that I've created, and I get access to that system, usually the next piece then is to perform reconnaissance from that system. And if there's no network segmentation, you essentially have kind of everything. So this defense in depth concept is a concept that, I think we kind of take, I know I kind of take for granted. I just kind of assume it. When I do my work, I don't stop and go, oh wait, is this a defense in depth concept? You just kind of always apply it. But for the exam, it's important to know what defense in depth is. It's also nice that because if there's a failure in one control, there might be another mitigating control or a corroborating control to pick up the defense. So multiple controls or safeguards is sometimes, if you come from a HIPAA world, safeguards is a better word for you, to protect or reduce risk to assets. Make sense? Due care and due diligence. I alluded to this just briefly on Tuesday. We use this thing called the prudent man rule. And it's essentially, what would a prudent man do with similar situation, or a reasonable person? What would they do given the same position, same context, same everything? It's okay to provide legal guidance to customers, but we just want them to know that I'm not a lawyer. If you want, and I was challenged on this once. It was when I was being interviewed to participate on the special litigation committee for this Target breach and subsequent work. And I had written something somewhere in some blog about due care and due diligence. And this lawyer, who was obviously a really, really good lawyer, said, hey, tell me about due care and due diligence. So it took me back, and I was like, well, this is what it is, but I'm not any lawyer. And he said, that's right, you're not a lawyer. Remember that. So, okay, so I remember that. So I'm not a lawyer, but I do know that these things. So when I'm advising CEOs and boards of directors and other people about due care and due diligence, I know the concepts, and you would also need to know the concepts if you served kind of in that same role or you were a chief information security officer. The important thing about it is it sets a bar. So this prudent man rule sets a bar. Sometimes people use best practices to set that bar. Sometimes people use, what are other companies doing? So, I don't know how many times I've been asked, okay, well, we rate like this. What do other people rate in our company? Are other companies doing this same thing? And the reason why they're asking that is we're trying to figure out where that bar is. If I fall below that bar, there might be a case for negligence or gross negligence. And where there's negligence, there's liability. If I'm above that bar, well, then I'm good, usually. So the important things to remember about due care and due diligence is due care is doing what a prudent man would do. Due diligence is actually doing it. It's the management of it. And it's formal. I added formal here to this definition because it needs to be documented. There needs to be evidence that I'm practicing due care. So due care, due diligence, two really, really important things to remember as you're designing and building security programs for your clients. Compliance, we mentioned before that compliance, I have a question. Do I see a lot of domain admin levels of security being broken out into different subgroups? Yes, I do see that. It depends on the environment. But if I can make the need to know principle, if there's a justification on kind of why I would do that, one of the things that's important to remember in security, I'm gonna cough, and I didn't really say it before, but it's important to remember that complexity is usually the enemy of security. So the more complex I make a system, usually the more difficult it is to secure it. So as you start adding layers, in the defense in depth strategy, it's a good thing, but try not to make it too complex because it becomes harder to secure it. So if you're going to do something like take domain admin levels and break them out into different subgroups, that's fine, but don't let it get out of hand. Don't let it get too wild and crazy. When you do your user account reviews, which you should be maybe doing quarterly, it makes it a lot more difficult. So something to keep in mind. Something you know twice, does that meet the needs of two-factor authentication? No, it doesn't. In the strictest sense, the three factors, and some people would argue that there's a fourth factor, and that's somewhere you are, but I don't buy that one because you can spoof that one easy. Some of your R would be like GPS coordinates or IP address that I'm coming from or whatever. So let's stick with the three factors. Something I know, something I have, and something I am. So if I use like two logins, for instance, or that's the most common, I would say, using the same factor twice, I would call that dual single factor, not two factor. So it wouldn't meet the requirement of strong or two-factor authentication. So good questions. I like questions. So thank you. It makes it feel like I'm interacting with you guys. Otherwise, I just feel like I'm sitting here talking, and it just feels weird. So compliance. So compliance is absolutely critical. You don't have an option to not be compliant, but you do have an option to not be secure. So compliance and security are two totally different things. In too many organizations, compliance drives security. What I'd like to see more of is compliance being part of security. So security driving compliance, which is a maturity thing. But they're two completely different things. We'll talk a lot more detailed in compliance when we get to domain 9. We are going to touch on it a little bit. We're going to go through some higher level stuff about compliance. Compliance at the end of the day is doing what you've been told to do. So you might have been told to do either from the letter of the law. Well, compliance is another funky thing too that I didn't really talk about this too much. But compliance, you have the letter of the law and then the intent of the law. Organizations that were following the intent of the law all along are finding themselves not having to struggle when auditors come. Organizations that are living by the letter of the law are having that trouble. So, take for instance in HIPAA, the security rule, one of the things it talks about is security risk analysis. So I can just, take out a spreadsheet, put some assets in there, put some values about risk, say, yeah, I did a risk analysis. That's kind of the letter of the law. The intent of the law is that you really do risk management. So it's, that's something important to know about, kind of how to approach compliance. If you approach it by the intent versus the letter, you're in a better spot. And then there's our definition of security again. So you're going to get sick of this definition of security, but that's important because you have to keep it in your mind at all times. I use it almost daily, even with people that have been in information security for God knows how long. Ask them what their definition of security is, and it's going to be different. And I don't know, most of us have been through this same type of training before. Most of us have read this before. And when I give them my definition, which is this one, like, oh yeah, that's right. This is like important, so don't forget it. All right, legal systems, 4 major legal systems. So civil law, common law, religious law, and customary law. Completely different legal systems. Sometimes people get confused about civil law and common law because they're very similar, and within common law there's a civil law. So these are legal systems. These are, and you kind of have to know that if you're going to internationally operate in different countries. Some countries might practice religious law, and that's going to be incompatible with what you're used to in common law. So you'll have to have a security program that can accommodate both, or accommodate one here and one there, and maybe a hierarching, whatever one above it. And customary law, which is, oftentimes customary law is not documented, so you have to ask questions in that one. So different legal systems in different parts of the world. Be aware of what legal system applies where you're at. The first one, civil law. So civil law is a very common legal system. It's codified laws. Typically you have a legislative body or branch that creates the law, codifies the law, and then it becomes law. And there's really no interpretation at the judicial branch. If there are interpretations, we go back to we get clarifications and things like that. So civil law, common law is really similar to that. If we go to common law, it's essentially the same, except there's a lot of weight given to judicial precedent and outcomes of previous cases. There's a lot of importance to interpretations, and sometimes people call this, legislating from the bench. This is what they're talking about. They're talking about, okay, the legislative branch creates this law, it gets written into the codes, and now it needs to be interpreted, and it doesn't get interpreted until somebody actually uses it. So you also find in our legal system, in the common law legal system, that people aren't really too concerned about new laws until somebody gets caught and then has to go through the process, because that's when it's going to be interpreted. And that's when I'm going to make, okay, now I know what you mean and I know how you intend to enforce this law. So you kind of don't really ever want to be that first person. But after that, it starts to become more clear. And the interpretations will change over time. So I might have a law that was written many years ago, and due to the interpretations over time, it still kind of applies today. So we have a lot of old laws in the book that still kind of apply today. Important things to remember: civil law and common law are almost the same, except for common law puts this weight to precedent. So that's really important. So this is going to definitely be the one that's going to be most referred to on the exam. Would be common law, used in U.S., Canada, UK, lots of them. Religious law. So we've heard, certainly I think in the United States, about Sharia law and what that all means. But religious law is where we use religious doctrine as the source of our laws or interpretation. For those of you who are biblical, understand, the Bible, kind of Old Testament stuff was very religious law. It was religious doctrine. That's how things were run. Now we kind of do things different. Certainly here in the United States, we use this common law thing. But so it's not just Islam that has a religious legal system associated with it. So does Christianity, so does Hinduism. The important thing to remember for the exam is that with religious law, it's doctrine and interpretation that drives the laws. Now, even within one religious doctrine, there might be different degrees of interpretation and enforcement to add, I think, more confusion if you're operating in a country that has these things. Islam, I think, is the one that's most common. It's the one that we read about the most in the news and what have you. And that's Sharia law. It uses the Quran and the Hadith, or I think I said that right. Those are the two doctrines that are used. So I think for the exam, if you know these 3 bullet points, I think you're good on religious law. Most of us aren't operating in these countries. And then customary laws. So customary law oftentimes isn't documented. Sometimes it is. But it really depends on the customs for the jurisdiction that you're in. Now, jurisdiction doesn't necessarily have to be a country. It can be a county. It can be a state. It can be just a region, just a place. It can differ from place to place. We don't have to deal with it too much here in the United States because things are very, very formal. But in different parts of the world, customary law is the way of the world. I mean, it's the way of the land there. Often undocumented, but very well understood by the people in that region. Best practice. So here, where it applies here in the United States is, I mentioned that due diligence piece. That's usually tied to best practices. Now, best practices in that context are being used as customary law. So in a common law legal system, we talk about civil law. Within that, oftentimes that's drawing from customary law, where we're taking best practices and kind of establishing negligence. So hopefully that makes some sense. I think this is why we pay lawyers a lot of money, is so they can figure all this stuff out for us. Hopefully find a good one too. So common law, this is the one that's going to be the most often referenced in the exam. So this is the one we're going to go a little deeper into. Within common law, the legal system is criminal law. Criminal law, in points to remember, the victim is viewed as society. Criminal law is written to maintain an orderly society or an orderly citizenry. The burden of proof in criminal law is beyond a reasonable doubt. So the burden of proof really lies with the prosecution, which is typically the state or whatever jurisdiction. They're the ones who are prosecuting the crime. The purpose of criminal law is to deter crime and to punish people for it. Those are the things you need to know for criminal law at this point. Anyway, now civil law gets a little more complicated. Civil law, I think, is the one that applies the most to us as information security professionals. There are a few people that actually go to jail because they're not doing security right. Trying to think. The only law I know of that has that is Sarbanes-Oxley. But that's kind of fraud. So if you break the law, or this would be, I guess, more of a customary law, if you're not practicing due care or due diligence in your application of information security, you're probably not going to go to jail. Not to say that won't happen someday, I don't know. But things that we read about in the news are all under kind of the civil law area of our legal system. In civil law, the victim is an individual, group, or organization. It's not the citizenry as a whole. Most commonly between two private parties. So it's one private party is going to prosecute against the other. There are cases where the government might, file a civil action where the government is the prosecuting, but it's still different. It's one organization against another. It's just the private party happens to be a government entity. One act can be prosecuted as both a criminal and civil procedure. So like the O.J. Simpson trial, you had that one act. Criminally, it was not guilty. Civil, there was a judgment against the defendant. So can be both. Damages are financial most often. Three types of damages that you need to remember. Statutory damages, these are ones that are prescribed by the law. So it's very clear what the damages are going to be. Now, the important thing to remember about statutory damages, because I think some people think that if I'm going to sue somebody that I have to prove that I lost something. That's only compensatory damages. If there's a statute that applies, then I can file suit for statutory damages. So I don't have to have a loss. I don't have to have an injury to file a lawsuit. Actually, I don't have to have anything. I can file a lawsuit anyway. And we've become very litigious, in this country. So there's a lot of these things going on. Compensatory damages are to compensate. So it's important to remember. So if what I'm compensating for is a loss, so that's the one that we're referring to when I say, well, I didn't really suffer anything. I don't have a loss that I can show. What they're talking about is compensatory damages. And then punitive damages. Punitive damages are usually those ones that are just astronomical, right? Where the judge awards $550 billion. That's a punitive damage. And you saw that in like the tobacco industry when they had those lawsuits going on. They were punishing them, discouraging the behaviors that they were engaged in. So in a security world, we kind of go through all of these. If you are on the unfortunate side of being the defendant in a civil case, you might be subject to all of these. The burden of proof. So the burden of proof, reasonable doubt. Here, it's just the preponderance of the evidence, which is basically, if you think of a scale, it's just tipped one way or the other. So if it's tipped in my favor, then I would expect to win that case. If it's tipped in the other party's favor, then I'll probably lose. That's kind of how it works. So there's a lot less burden of proof, and I would assume it's probably, I'm not a lawyer, but I would assume it's probably easier to win civil cases than it is criminal. So good stuff. Any questions, feel free to ask. Now this last one, so we're still within the common law legal system. We had criminal law, civil law, now we've got administrative law. Administrative law are laws enacted by government agencies. Typically it's from a presidential issue or a directive or an executive order of some sort. It can also come from the legislator or the legislature, and then the president would sign. Now, the way it works is the president isn't the one who actually goes out and enforces these things. It's a government agency that does. The agency interprets the law and then enforces it. So if you look at like HIPAA, for instance, HIPAA was passed by the legislature, signed into law by President Clinton, and then it was the Department of Health and Human Services that was tasked with making this thing happen. So they would continue to re-engineer the rule. And then another agency actually altogether, the OCR, the Office for Civil Rights, actually enforces it. That's one example. In GLBA, it's given to the FFIEC, and then there's maybe the OCC, the FDIC, or whoever actually enforces the law. So that's kind of how administrative law works. Now, it's government mandated compliance. I gave you an example of HIPAA and FFIEC. There's also FCC, FDA, FTC, FINRA, tons of administrative laws. Now, one of the challenges with administrative law is I don't have a lot of recourse. So if, let's say that the OCR issues an order called Compliance Action Plan, CAP, whatever. I don't have a lot of recourse. If I decide to appeal, who I'm appealing to is a court within that government agency. So it's not going to be impartial. So and this I've read numerous, and I actually was sat in a presentation once where the FTC filed suit against a healthcare organization, and the healthcare organization just disagreed with the FTC and decided they were going to fight it. Well, at the end of the day, what happened was the company ended up going out of business because the FTC just kept issuing more and more and more orders, and every time you appealed, you appealed to a court that was established and within the FTC, so the judge was an FTC employee. So I guess at the end of the day, what I'm saying is don't really fight it. Just do what they say and try not to make them mad. So the question is, are we going to need to remember all of that? Maybe. Yeah, it's going to be a lot of memorization, but I do want to encourage you to not give up. When you get through, like I said, I'm a 3-pass kind of guy, so usually when I'm preparing for something I've never really learned before, the first time I read the book, I don't know anything about what I just read. It's confusing as hell to me. I don't know any of it. And I remember this when I did the CISSP back in the early 2000s. The second time I read the book, I wasn't stuck any longer on terms. I was able to kind of put concepts together. And then the third time I read the book, I was able to kind of focus on the mastery of the concept. So I had to read the book 3 times. The book that I read, this is a kind of a nice book because it's very concise and it's to the point. These are really just the facts that you need to know in order to pass the exam. The book that comes from FRSecure, I think, is 1,000 pages long. So that one's a much harder one to read. But yeah, you'll have to remember a lot of stuff. So good question again. And then liability. So where does liability, this is a concept, where does liability lie, I guess? And at the end, so liability is right. Who should be held accountable? Who should we blame? Who should pay? Somebody's got to pay. Something bad happened. We kind of have this mentality, certainly in the US, where something bad happens, somebody's got to pay for it. And so that's liability. Where we determine where liability lies is typically we apply the prudent man rule. And that brings us back to the due care and due diligence. So due care, again, is what would a prudent man do? So it's doing the prudent man piece. The due diligence is the management of it, and it's the formality around it. So, questions? We're going to dig into a little bit of evidence now. So, do I find that some sections were easier to memorize than other? Yeah. Well, no, I don't know, actually. I came from a technical background, so I think it's easier in general for somebody who's starting a career in information security to have a technical background, because the technical parts are the ones where I think most people get hung up when they're studying for the exam. I think they automatically think that, I'm not technical, I don't get it. So when you start talking about things like TCP IP, and you start talking about TCP headers and where intrusion detection and prevention fit and all these things, that's where I think I lose most people. So I think most people struggle with that. But I think it's all kind of hard to memorize if you haven't done it before. Once you've done it a couple times, it's really comes second nature. It's not very difficult. So again, I strongly encourage you to just struggle through it. You're going to come out the other side and be like, okay, I got it. It seems overwhelming at first. Certainly when you kind of go from what we talked about on Tuesday and then bam, we're getting hit with 500 different things in chapter 2, and I can't draw the line to some of them. So at this point, we're only 45 minutes into the class, and we've already talked about our definition of information security, privacy. We've talked about some rules and regulations, talked about prudent man rule. We talked about all these concepts, and now we're going to go into investigations and talk about the types of evidence. And before we get done with this class, we're going to talk about risk analysis. We're going to talk about information security governance. We're going to talk about compliance a little bit more, talk about types of attackers. So it's meant to be an onslaught right now. It's natural. So investigations, this really plays a huge role if I'm doing any investigations. So I normally do investigations when something bad happens. Two parts that are really important is how I collected the evidence and how I handled the evidence. Now, these other things are important, but I don't really think of them that much when we're actually doing an investigation. But it's important to know. It's important to keep in the back of your mind they're the types of evidence. So real evidence is tangible. It's something I can touch. It's physical. So in a computer world, it would be the computer itself. It would be the hard drive itself. It's not the data on the hard drive that's real evidence. It's just the hard drive. So that's real evidence. In a criminal case, and take this back to like a murder investigation, this is the best kind of evidence. DNA analysis type evidence, or the murder weapon. Those things are real evidence. Those are the best kinds of evidence. Unfortunately, they don't help us much. We're talking about information security investigations, but I need to know that. Direct evidence is testimony from a first-hand witness. If it came from somebody who didn't witness it firsthand, it's called hearsay evidence. Hearsay evidence is not admissible in a court of law, except we're going to talk about a couple of rules that actually make it for a computer that is admissible. So, but in general, first-hand witness testimony is direct evidence with one of the five senses. Circumstantial evidence creates kind of everything around the facts of the case, but it doesn't prove the actual case. So it's the circumstances that lead me to a conclusion. That's circumstantial evidence. Corroborative evidence is evidence that corroborates other pieces of evidence, so it strengthens evidence. And then hearsay evidence is secondhand. So if I heard it from, this is like, what do you call that when somebody, oh man, I think it's Thursday, gossip, that's hearsay stuff. So for you gossipers out there, you know what hearsay evidence is. So these are the five types of evidence: real, direct, circumstantial, corroborative, and hearsay. Now hearsay is secondhand evidence. So the reason why this is important in information security is data was created by things that happened. So it's not direct evidence, plus there's no witness of it. So when I come and look at a log file, I'm looking at something that's kind of after the fact. So in a court of law, that's called hearsay evidence. So when I use log files to prove a case, or I do an analysis of a hard drive, and this is my conclusion, that's all hearsay evidence. So if we just stuck with these types of evidence and said that hearsay evidence is not admissible in a court of law, then I could never prosecute a computer crime based on the way things are written. So there are some exceptions to it. The rules, Rule 803 and 804 of the Federal Rules of Evidence, permit exclusions to Rule 802. So Rule 802 is the hearsay evidence rule that says that these things are not permissible. So business and computer-generated records, logs, are generally considered to be hearsay evidence, so I had to have exclusions in order to prosecute computer crimes. So that's why Rule 803 and 804 largely were written. So I give you, what Rule 803 says, and I highlighted the things that were important that show. I'm going to minimize the video because I don't need to look at that. So the parts that are important: in the course of a regularly conducted business activity. So what this means is I normally have logging turned on. I didn't just turn it on to try to collect evidence. It's normal course of business. The regular practice of the business activity to make a memorandum, report, record, or compilation. So that's one part of 803 that's kind of important if I'm determining whether or not this evidence is something I want to present in court, or the lawyer is advising us on what we need to present in court. It needs to be part of a normal business activity, something that I already do. Now there's a Rule 1001, which allows for the admissibility of binary disk or physical memory images. If data are stored in a computer or similar device, any printout or other output readable by sight, shown to reflect the data accurately, and it is an original. So what this means is that I can take, the process of doing an investigation is I never do my investigation, or we never do our investigation on the original. Instead, what we do is we create a binary copy of the original. A binary copy is a block-by-block image. It's not just a copy, but it's an exact replica of the original. And then I do my investigation on that copy, so I don't ever destroy the original. And then I create my report based on the investigation of the copy. That is admissible according to Rule 1001. A lot of stuff, I know. Yeah, so memorization, I guess. To give you an example, in the exam, they might mention Rule 803 and 804. Just know what they are, sort of. I mean, you don't have to know, you don't have to memorize the text of these rules, but know kind of what they are and why they're important. So I don't know, any questions or not? Legal aspects of investigations. So in the court, they want the best evidence possible. The best evidence you could possibly have is direct evidence. So if you had direct evidence, that's great. In most cases, you don't have that because of the type of investigation you end up doing. Evidence needs to be relevant, authentic, accurate, complete, and convincing. So when the judge is looking at evidence, or when the counsel is looking at evidence and presenting either to the judge ends up kind of being the referee, this is what they're going to use to determine if this evidence is even worthy of consideration. Is it relevant? Is it authentic? Is it accurate, complete, convincing? Is it helping to make the case? That's kind of what the best evidence rule. Looks like I have a question. Is a syslog remote record inadmissible since it is not a direct copy of the system? It is admissible. It's admissible under 803, I believe. Let's go back. So it would be admissible under 803 because it's done as a normal business activity. So the syslog remote record is an actual original. What it's referring to in Rule 1001 is if I'm using this hard drive or the data that's on this hard drive to help myself make a case, I'm permitted to make a binary copy of it, a direct copy. What Rule 803 is saying is that anything that's kind of created as part of your normal business activities is admissible as hearsay evidence. So having your syslog remote record, so having a centralized logging system and logs are being sent there and something bad happens and I want to use the logs that are on my syslog server as evidence in court, you can do that according to Rule 803. So good question. So best evidence rule, secondary evidence, copies versus originals, that would be called secondary evidence. Logs, documents, all that is secondary. Evidence integrity is really important. So when you think about it, so let's say that I'm on the prosecuting side, so I'm creating, collecting, preserving evidence in preparation for maybe a criminal case or maybe even a civil case. One of the first things that opposing counsel is going to attack is going to be the integrity of my evidence. Is this even good evidence, or is this trash? Is it reliable? Can we trust it? So that's one of the first things that they're going to attack is the reliability of your evidence or your evidence integrity. Another thing they're going to attack, which is closely related, is who had access to this. Where did it go? Once you collected the evidence, where did you put it? Was it secure? Did other people have access to it? Could they have changed it? That gives them an out, right? That gives them something to challenge. So just when you're collecting evidence, and not everybody does this. Not everybody collects evidence. A lot of people outsource investigations. So it's not like you'd be tasked with doing this as well as everything else that you do, but it's important to know, even if you hire an outsider to come in and do an investigation for you, if you're watching them and they don't have a chain of custody form and they're not having you sign something when they're taking something off site, that should be a big red flag that, we're kind of losing chain of custody. This is something that might be an issue if it goes to court. And prosecuting criminal computer crimes is really hard because of the fact that It's hard to preserve evidence. Oftentimes, you have specialists within the FBI or NSA or some other highly trained people are involved in collecting that evidence in computer crimes. It becomes even a bigger issue. I mean, if you think of this, if you were a criminal in the United States and you wanted to attack PayPal or some other organization, if I were to use an anonymous proxy in China and then maybe an anonymous proxy in Iran, and then from those systems attack PayPal, and let's say that I get caught, they even know it's me sitting in my house in Indiana or wherever I'm at, they go to build this case. They have to prove it beyond a reasonable doubt. There's probably not a good chance that they're going to be able to get those log files from the anonymous proxies in these two countries that don't cooperate with the United States. So you can see the difficulty sometimes, in prosecuting computer crimes. It's an admirable job they do. Other legal aspects. So reasonable searches. This is important to remember because I kind of want to make sure I'm on the right side of things here. If I'm not on the right side of things, I might be breaking the law. So most people know about the Fourth Amendment of the U.S. Constitution, which protects us all from unreasonable search and seizure. So I need to have things like search warrants. There are some exceptions to having that. Plain sight. So if something's in plain sight, as law enforcement, you can just go and get that, grab it. Public checkpoints. It's another way that I can gather evidence without a search warrant. Another piece is called exigent circumstances. So this is if there's an immediate threat to human life or that the evidence will be destroyed. If those three things exist, any one of those three things exist, I can search. If I'm law enforcement, I'm not law enforcement, but if I were, I wouldn't need a search warrant. I'd be able to, well, not really search, I'd be able to get it, essentially. Now, what's important here is this only applies to law enforcement. In all court cases, they're going to go through this process to determine whether or not the evidence was obtained legally. If it wasn't, it's going to get thrown out. Another bad thing that happens is, let's say that there's an investigation and my first thing is to call law enforcement. So I call the police and the police say, well, I need you to go and seize that computer and start an analysis of the drive. Well, now I've been instructed by law enforcement. That puts me under what's called the color of law. If I'm operating under the color of law, that means I need to have a search warrant. So if I go and do that, I could be breaking the law. So that's why it's not always a good idea right out of the gate to call law enforcement. Another bad thing about calling law enforcement right away is if they're going to go at this as a criminal investigation, which they would if they're a law enforcement, they now have control over the investigation. So I've kind of lost control of the investigation that maybe I wanted to lead. Now it's kind of theirs. That's another issue. And I'm also kind of reliant on their expertise. And I don't know if you've worked with law enforcement before on computer crimes. You get widely different skill sets in different jurisdictions. In some places, they have no idea what they're doing. So you kind of turned it over to somebody who's lost. And there was another reason why I don't often call law enforcement right away. Oh, another thing is now it's gone outside of the organization. If I can, and I'm legally able to keep bad things internal to the organization so we can deal with it internally, that's usually a best option. If I bring law enforcement in, now I've lost control of that. So it may go public. So things to keep in mind. But here, the thing to remember is if I'm doing something that law enforcement told me to do, I may be operating under the color of law. And if that's true, I need to play by the same rules that they do. Other legal aspects of investigation, we've got this thing called entrapment and enticement. The big thing about the difference between these two is really the intent of the person we either entrapped or enticed. Entrapment is persuading somebody to commit a crime who had no intention of committing the crime. If that's the case, they will use that as a valid legal defense, and you won't win. Enticement is something completely different. It's persuading somebody to commit a crime who already had that intent to commit the crime. And somebody, I think, mentioned on Tuesday, or maybe, I don't know who I talked to anymore, but somebody mentioned something to me about honeypots and whether I thought those were a good idea. Honeypots in particular kind of can cross the line between this entrapment enticement thing. So what I've always advised is if you're going to use honeypots, just run it past legal counsel to make sure that you're setting it up in a way that it's more enticement than entrapment. Now, it's not illegal really for you to entrap somebody unless you are law enforcement. But if I'm going to use these honeypots in a way outside of just gathering research information, it's important to know this entrapment enticement thing. So two differences. One's good, one's not. Enticement's good. Intellectual property. So bam, we're going on to another thing. So more stuff to remember. So trademarks and service marks are important. The R means it's been registered with the U.S. Patent and Trademark Office. The TM means that I just put it on. I don't have to register a trademark in order to use a trademark. You can see up on the top right where you see the FRSecure and you see our logo up there as a TM. That means it's not a registered trademark. We do have some registered trademarks. So one of the things that's a registered trademark is kind of our core thing that we do, and it's called FISA. It's a FISA score. That's a registered trademark. And it only costs, I don't know, $275, something like that, to register a trademark. And why I would do that is it protects my brand. So it's if I create a brand and I want to protect it, I don't want somebody else using it, I would put a TM on it. Or if I want it to be more formal and more enforceable, I would make it a registered trademark. So it applies to names, logos, symbols, images, those things. TM, anybody can put it on there anytime they want. If you're using Word, it's left paren, TM, right paren, and bam, it'll make that cute little TM for you. And then R is a registered trademark. So if I see an R, that carries a little more weight to it. But they're both trademarks. And then there's a superscript SM. Now Word doesn't do that for me. If I do the left paren and SM right paren, it doesn't superscript it for me. It just does nothing. So I couldn't make that look pretty for you guys. But if I see a superscript SM, that's to brand the service. So it's not for a name, logo, or symbol or image. It's for a service itself. So those are trademarks. There is no time limit to trademarks. As we get into patents here, patents have 20 years. If we get to copyrights are typically 70, 95 years. But patents provide a monopoly in exchange for the inventor making that public. So I may have created something I think is really cool. I go file a patent. The patent is essentially saying, all right, we're going to allow you to make money off of this, protect your invention, but in exchange for that, you need to make it public. So in the patent itself will be your work papers, your diagram, whatever your invention is will be published, so everybody will be able to see it now, but nobody will be able to use it without your approval. Assuming the patent was written, in an enforceable way. Sometimes patents are written so specifically that it's pretty easy to get around it. So you'd go through a patent attorney. There's a whole practice on that. Invention must be novel and unique. So if I'm going to invent something, it needs to be something new. It can't be something that somebody else has already done or something that somebody else has already patented. I can't use a patent without permission. That's patent infringement. Generally, patents expire after 20 years. And you see this a lot in like the drug market. That's where generics come out. So if I come out with a new drug and I file a patent on this new drug, prices are through the roof because I need to recoup the costs of creating this drug. There's a lot of costs involved. So there's a reason why the prices are so high. But another reason why the prices are so high is because I have a monopoly on that drug. I'll have that monopoly for 20 years. And then after that 20 years, then you'll see all the generics because now it's open to anybody. So after a patent expires, anybody can use my invention to create their own stuff and sell it. So that's kind of how patents work. Copyrights are around, do I have another one before that or after? No. Okay, so copyrights. Copyrights are around expression. So, or software can be copyrighted. What am I thinking about an expression? I can't remember. So software is often copyrighted, typically covered under copyright law. There are two limitations, or kind of exclusions, I guess, to copyrights. It's not that I can use this software for other purposes. So there's the fair sale, which means I can sell it to somebody else. So if I buy a piece of software from Microsoft and I don't need it anymore, I can sell it to somebody else. Now, I'm also subject to a license agreement, but that's different. But there's the fair sale doctrine, and then there's the fair use doctrine, which allows me to make duplicates or copy the copyrighted material. There is a law written around that, which is the Copyright Act of 1976. I don't need the consent of the copyright holder. Now, there's additional things that will be applied to the fair use doctrine. I can't really profit off of the copies, so I can't buy something copyrighted from somebody, make 500 copies of it, and then go sell those 500 copies and make a profit. Really, the duplication piece is meant to be for my own use. Licenses is we all see these all the time. We all read them word for word, I'm sure. I have stories around end user license agreements. I had a lawyer once at a public company. I was the CISO, and I had to get all contracts approved from the CLO, the chief legal officer, and I didn't realize that it applied to end user license agreements as well. And so he must have been new, but he redlined the Microsoft end user license agreement and sent it to Microsoft. I don't know why obviously that went nowhere. But end user license agreements are really, they're separate from copyright law, and the maker of the software or the distributor of the software that has the terms and conditions of using that software. Trade secrets. Trade secrets are the secret sauce. So like Coca-Cola's formula for making their soda is a trade secret. It's a secret sauce. It gives them a competitive advantage in the marketplace. So trade secrets are proprietary information, and they give me a competitive advantage. Colonel Sanders has his spices thing. I mean, that's his secret sauce. Now, the important thing about trade secrets is they have to be actively protected to be enforceable. So if I didn't put adequate protections around the trade secret and it gets lost or stolen, and I may not be able to get that back. I may not be able to enforce my trade secret. So, and here again, we apply the due care and due diligence, kind of the prudent man rule. What would somebody else do to protect this information? Are you kind of following that, or did you not even have a firewall in place? It was out on an FTP server somewhere. You just didn't actively protect it. So you can, if you don't adequately protect your trade secrets, you could go out of business because it gives you that competitive advantage. So I have written there, if an organization does not take reasonable steps to protect a trade secret, it's assumed that the organization doesn't enjoy a competitive advantage, which leads to the conclusion that it's not actually a trade secret. So it's important to remember. And I have a question. Is active protection a legal consideration or something you should just do to secure it? It depends on where, what context you're in. Active protection would be, I would apply it as best practices, due care and due diligence. Now it becomes a legal consideration if I'm going to protect that trade secret in court. So I think it's both. I would actively protected to me would mean that I'm treating this like it's actually something that gives me a competitive advantage. It's confidential information. It's something that needs to have an added level of security. It needs to follow that need to know principle. It's kind of locked down. So if that's how I would approach it from a security perspective. In a legal perspective, it's kind of when something happens, they're going to make a determination on whether or not it was actively protected. So you don't get as much say there. Hopefully that answered your question. All right, intellectual property attacks. Intellectual property attacks, tons of different intellectual property attacks. These aren't really, I guess they're kind of more threats maybe. So it's a constant problem, protecting intellectual property. You've got piracy and copyright infringement things. I mean, you can go and get cracked copies of software in a bunch of different places. That's all piracy and copyright infringement. It's easy to get movies, for free in different places. It's easy to get songs for free in different places. That's all piracy and copyright infringement. Cyber squatting is, I register a domain name with the intent and purpose of squatting on it. So I have no intent in building a business around it. I have no intent of doing anything legitimate for it. The reason why I bought it was to prevent another company from buying it. So I'd be squatting on that domain. Typo squatting is, I register a domain name that's very similar to a popular domain name. It's maybe just a typo. Google owns a lot of the typo squatting ones around it. So like, if I add two G's, G-O-G-G-L-E, or whatever, it's using those typos to obtain, it's always money motivated. So usually what you see in typo squatting is a bunch of ads and things like that, trying to generate some revenue. Counterfeiting is a big thing. I've a story with counterfeiting. I was working for a company, it was a manufacturing company that made this really cool thing, and it measured microindentation. So it was, which would tell you the hardness of materials. So they take this thing that they created, which is really, really cool, and it would measure the hardness of things based on, kind of hitting it. But it was very, very sensitive. Tolerances were really tight. And so it was this cool thing that was new to the market, and they wanted to do business in China. And I remember I don't know why their lawyer was asking me, because whatever, but it was asking me, how do we protect this from counterfeiting? And I'm like, in China? I have no idea. China replicates entire Apple stores that look exactly like Apple stores that aren't Apple stores. They can counterfeit an entire store, so I don't know how you can protect against, some of the counterfeiting that goes on. But that's definitely an attack. And then dilution. Dilution is, I might have a brand. Kleenex, I think, was used in the book. Everybody refers to, paper tissues now as Kleenex. Everybody refers to bandages that you put on your little cut as Band-Aids. Whether it's actually a Band-Aid brand Band-Aid or it's a Q-Tex brand Band-Aid, they refer to it as Band-Aid. So that would be dilution, where my brand has just kind of been diluted because everybody refers to it that way. All right, onward. Piracy, legal and regulatory issues. So piracy, confidentiality, again, only confidentiality of personally identifiable information. So it's definitely a subset of information security. In most organizations, we treat them as two separate disciplines, for better or worse. Examples of PII, names, addresses, and I say maybe because I don't know if you guys remember, I don't know how many years ago it was now, 8 maybe, where there was, I can't remember the name of the company either, but there was a company that used to do mailings, used to do email mailings for bigger companies. And so they had these huge mailing lists, which had names and email addresses of, their customers. And then this company would send out email campaigns on behalf of these big companies. Well, that mailing list company was compromised, and now millions of names and email addresses were exposed on the internet. On the surface, it doesn't seem like such a big deal, but if I have a spreadsheet with millions of names and email addresses, and the title of the spreadsheet is US Bank Customers.xls, it's really easy for me to put together a pretty effective spear phishing campaign and attack all of those people. So it may not seem like it's PII, personally identifiable information, but in this case it kind of was. Social security numbers are certainly personally identifiable information. Protected health information, PHI, which is a term that we use in HIPAA in healthcare, that's certainly PII, bank account information, sort of. And then we have numerous privacy laws throughout the world. This is a big deal if we do business in any part of the world, because like in Europe, for instance, they have the EU privacy rules. I have a question. Yay. Is it PII if you can Google it? Does it make it publicly accessible or public domain? So it's PII regardless of whether you can Google it or not. It's Epsilon was the mail company. Thank you, Eric. I said your name even though you sent it to me privately, but that's because you're kind of a stud now. So PII is PII regardless of where it is or whether it's publicly accessible or not. I think it depends on what the definition is that you're going to use for PII, which is still a debate in many circles. It's still a debate in certainly in healthcare. We still debate whether this is actually PHI or not PHI. If it just has a name and a date, maybe the date that they visited, is that PHI? And some healthcare organizations will say it is, and others they'll say it isn't. So I think PII and PHI are terms that I think everybody kind of generally understands, but I think when you get down to the details, they don't understand it. So PII is tough. What's the best definition of PII? I'll give you my definition. My definition is if I can use this information to identify a certain person, that's PII, and it's personal. So it's stuff that wasn't intended to be public. So just having my name, that's not intended to be public. Sometimes I use the phone book reference. So everything that's in the phone book is not PII. If you add anything to it, it becomes PII. That would be my definition. Lots of privacy laws. Here's some. So we have the European Union. They have their own protection directive. It's very aggressive. It's a pro-privacy law. Notifies individuals where their data is gathered and used. I don't do business in the EU, and I have very few customers who do. So I don't deal with this one often. I have sat in on presentations and seminars of lawyers who work with the EU Data Protection Directive. And it's pretty interesting. I mean, it's very, very strict. It's very, very no nonsense. They do enforce it heavily and actively. So it's definitely different than the way we do things here in the U.S. Some of the things that are required in the EU Data Protection Directive, I have to allow for opt-out for sharing with third parties. Opt-in is required for sharing the most sensitive data. Now, most is in quotes because it's up to the EU to determine if this is most sensitive data, and I think that's changed a little bit over time. And then reasonable protections, and there's no transmission out of the EU to another country unless that other country is perceived to have adequate, which ends up being equal, privacy protections. This is a problem because in the United States, it doesn't meet that standard. Who's making that determination ends up being the EU. So what came out of that is the EU-US safe harbor, because if it went forward the way it was without the safe harbor, you would essentially stop a lot of commerce between the European Union and the United States. So they had to create this EU-US safe harbor kind of for that purpose. PHI is PII that connects in any way to a medical provider. I think that's a great definition. Do you see the U.S. moving towards the EU directive? No, I don't. I think there's too many conflicting interests here for that. We can't get a nationwide data breach notification law, let alone tackle something like this. So EU safe harbor. So if I'm a United States business, and I want to do business in EU, and it's going to pertain to me collecting any information, personally identifiable information or private information from citizens of the EU, I need to comply with the EU-US Safe Harbor. It's optional unless I'm engaging in those activities. I will be held to that standard. Other privacy things from around the world, we have the Organization of Economic Cooperation and Development, OECD privacy guidelines, 30-member nations. Many of those nations are from Europe. The US is also part of that. Mexico, I think, is part of that. It focuses on these bigger issues that affect the global economy, so it's not just this. OECD doesn't just deal with privacy, they deal with other bigger issues, but they did issue some privacy direction in these guidelines that were issued in 1980. 8 principles. You don't have to memorize the actual principles, but what you do need to know for the exam is that there's this OECD privacy guidelines that does affect privacy. 8 driving principles for your information collection limitation principle, data quality principle. They're all pretty self-explanatory. So when you talk about the collection limitation principle, this really deals with, I'm only collecting the data that I need to, and there is some disclosure of what that comes into the purpose specification principle too. Data quality principle, so it has to be accurate. That's an integrity issue. Use limitation principle, security safeguards, openness, individual participation, accountability. This is not mandatory. There's nobody who's enforcing these on people. And that's good because they use the word guidelines. Now, guidelines, as we get to that, are optional. They're intended to be optional by definition. If you have a government regulator who's issuing guidelines, that's different. That's debatable. So I don't like how guidelines is used. I wish everybody used it the same way. But here it actually, I think, is used the right way. It's not mandatory. Other rules and laws, I'm going to kind of pick it up because I've got 35 minutes because I think I'm not going fast enough for you guys anyway. HIPAA's fun. Enjoy that. It's 2 A's, not 2 P's. I've seen a lot of people do the HIPPA. And the very first marketing thing that we used at FRSecure back in 2008 actually had HIPPA, believe it or not. We didn't catch that. So Health Insurance Portability and Accountability Act. Now you could debate whether it makes it actually portable or accountable. Overseen by the Department of Health and Human Services, enforced by OCR, the Office for Civil Rights. Essentially 3 rules. I mean, if you were to simplify it, we've got the privacy rule, the security rule, and the breach notification or breach rule. It applies to covered entities, but it also much more applies to business associates. Essentially, business associates are people who do business with covered entities, or it's not like what it used to. It was very much focused on healthcare organizations, and now it really applies to healthcare organizations and other people who are involved in the collection, processing, handling, access to protected health information. So it's definitely applying to many more organizations, and it's catching people by surprise. Certainly the business associates, I think, maybe some of them are surprised. So HIPAA originally passed in 1996. It's been around for a long time. Security rule was finalized in 2003. It was modified in 2009 with high tech, and then the omnibus rule was finalized in 2013. So we kind of have this, I think, status. I mean, we kind of have this, it's like here now. I mean, like everything is kind of there, I think, with HIPAA, which is kind of cool. OCR issues these things called audit protocols. They do audits. Important thing to know, we're not going to dig in too deep with HIPAA right now because we will get into it deeper later. But the security rule mandates certain administrative, physical, and technical safeguards. Now that should ring a bell because that also fits with our definition of information security. We talk about administrative, physical, and technical controls. Controls and safeguards are interchangeable. So this is right in line with what we're thinking anyway. Risk analysis is required in HIPAA. I got a lot more things to say about HIPAA, but I'm not going to do it right now. Other rules and laws, Electronic Communications Privacy Act just deals with privacy. Electronic communications, warrantless wiretapping, it was amended and really weakened with the Patriot Act that came after the September 11th attacks. Computer Fraud and Abuse Act, Title 18, Section 1030. You don't need to remember probably Title 18, Section 1030. It made me seem a lot smarter if I put it on the slides for you guys. Really, it's the Computer Fraud and Abuse Act. If you remember that, that's good. This is the #1 law that's used to prosecute computer crimes in the United States. It was originally enacted in 1996. It's been modified and amended numerous times. The last time in 2008. This is the same act that was used to prosecute all of your big computer criminals that you've read about over the years, Robert Gonzalez and Adrian Lamo and on. So that's an important law. Patriot Act of 2001, like I said, it weakened privacy protections and certainly warrantless tapping, expanded law enforcement, their monitoring capabilities. It allows, in some circumstances, and primarily around communications, search and seizure without immediate disclosure. So it sort of scares people, and there's been a push to try to repeal it, but it's still there. GLBA, Gramm-Leach-Bliley Act. This came as a direct result of the 90s when we had all those fraud things going on, Enron and MCI WorldCom, and all those things were actually no, that SOX. GLBA came about sort of on its own. I don't know what really spurred that one on. But 1999, really it's about the confidentiality and integrity of consumer financial information. The agency that's in charge of it, sort of, is the Federal Financial Institutions Examination Council, more often referred to as FFIEC. There's a lot more to this one too, and we'll talk more about this one in a future class. SOX, there it is. That's the one I was really talking about the scandal, kind of scandalous. So California Senate Bill 1386, this is a state law. And the reason why it's mentioned here is this is one of the first data breach notification laws. Now there are 47 states that have data breach notification laws, so this was kind of the first one that kind of led the charge. Regulates the privacy of personal information. It also mandates a notification if there's a breach of personally identifiable information. So that's a tip of the spear one. Sarbanes-Oxley, 2002. This one came out of the fraud stuff in the 90s. It really applies to financial reporting, but how this affects security is, in order for me to demonstrate accuracy in my financial reporting, I have to have certain things like access controls, change control, and other things in place around my financial reporting systems. So it's not uncommon for information security personnel to get brought in on SOX audits. It applies to publicly traded companies. So if you're not working in a publicly traded company, then chances are you're not really dealing with SOX. Intentional violations of this one can land you in jail. Another one, PCI. PCI DSS, like I mentioned earlier, version 3.2 is out, so there's a new version. They push off kind of the dates when things have to be in place for a little while, so it's not like you have to rush out and change everything right away. This is not a law. This is a standard. It's an industry standard. It means the industry is kind of managing it. It's not, there's no government agency associated with this yet. I think it will happen probably in the next few years, but it just because, well, you have to know more about PCI. We can have that as a side conversation. Applies to cardholder data. That means credit and debit card data created by the major card brands, Visa, MasterCard, Discover, etc. Requires merchants and others to meet a minimum set of security requirements. It's fairly prescriptive. If you've never dealt with PCI DSS before, it's fairly prescriptive. And it's meant to be black and white. In reality, it's pretty gray, because what happens is I have a prescriptive control. I'm going to interpret that control in any way possible to make it fit my existing controls, and that's where the gray area comes in, is in the interpretation. Yeah, are you referring to that same thing, Eric, the version 3.2 that was released today? You have to say yes in your question thing. Yeah, yep, 3.2 is out today. Merchants mandate security policy, devices, control techniques, monitoring. This anybody can go download this standard. Just go to the PCI Council's website and grab a copy and take a look at it. Yeah, I'm not going to talk much more about PCI right now. Breach notification laws. I mentioned that there are 47 states that have breach notification law. There is no federal breach notification law. There have been numerous attempts to pass a federal breach notification law, but at this point there still isn't one. Now the challenge is if I'm running an information security program and I work closely with a compliance officer and we're trying to figure out these things, I have 47 other laws that I have to deal with if there's a breach and I do business in all these states. That can be a real challenge at times. Now, the good thing is that these 47 state laws really aren't that different. So you can take the one, you can kind of apply them to all. But conflicts do arise from interpretations, jurisdictions, definitions. Some of the laws have safe harbors for encryption. So essentially, if this data were encrypted and I can kind of prove that it was encrypted, then I don't need to notify. That's the safe harbor piece. So another good incentive to implement encryption in places. I'm a security guy, so I think everything should be encrypted. If I could figure out a way to encrypt people, I would do that too. There's also other laws, and they're not really mentioned in the book, but there are 2 data protection laws. There's one out of the state of Massachusetts, another one in Nevada, which have prescriptive things that I have to have in place in a security program if I have data belonging to one of their citizens. Now, not just one of their citizens, but if somebody had ever lived in Massachusetts. So you might as well apply those laws too and just be aware of what those are and make sure you're compliant. And then there's also, when we're dealing with government entities like states and federal, state, and county, city, there's also these things around Freedom of Information Act things, and they may have state laws that say that there's openness and open disclosure about the information we collect and what have you. A lot of times that goes counter to some of the things we do in information security, so it can get pretty confusing quickly. That's why I don't like compliance. I like doing security according to security, and then make compliance a part of it, as opposed to trying to run a security program trying to figure out what all the compliance requirements are. Vendor risk management. So vendor risk management is certainly a place where there's great opportunity in most organizations. So if I'm a big company or any company and I'm doing business with or I have a vendor who helps me do things, I'm sharing information, giving access to my systems, whatever, there's risks associated with that. And understanding those risks is really important in the management of my overall security program. So some things that we see that people do, and it's mentioned in the book, is I can have them attest to some level of security. So we can either do a risk assessment, they can do a risk assessment, and then provide me with the results of that risk assessment, which attests to their level of security. We see many organizations asking for a SOC 2. There's 2 different types of SOC 2s. There's a type 1 and a type 2. A type 1 is kind of a snapshot in time. A type 2 is sort of a snapshot in time. There's a beginning and an end, and during that period, that attestation period, you have to make sure those controls are operating. I could ask for an ISO certification. So ISO, and we'll get deeper into this stuff. So if you don't get it all right now, that's okay. We're going to hit it again later. But ISO, this would be the ISO 27001 certification, basically attesting that I've got these controls for my ISMS and blah, blah, blah. PCI DSS ROC. ROC is a report on compliance that could also be used as an attestation. So that's one way I could manage my vendors to make sure that they're doing the right things that they should be doing around security. In each one of these, there are pros and cons and holes. So I'm not going to say any one of these is the best way to do it. I think it kind of depends on how you're doing it with each one of these. One of the things we often ask about when we're doing an assessment of an information security program is not so much do you have the right to penetration test. That's not often something that we ask, but do you have the right to audit? So what we'd like to see is in contracts with vendors that there's a right to audit in that contract. So really, according to the terms and conditions of the contract, if it's just open, ideally we'd like to audit when we want to audit. And so we want to come in and audit your controls to make sure that they're operating the way they should be or the way we want them to be. So having those in contractual language in vendor agreements is one way we could approach this. We also need to take into account procurement. So I may not have a vendor who's actually in my environment, but I use this vendor to procure certain things. Some of those things might be critical to my operations, which is a big deal if it comes down to a disaster recovery scenario or something like that. If that vendor is not reliable, or that vendor goes out of business and it's kind of a one-of-a-kind thing, I need to take that into consideration, in my procurement. Other things, acquisitions, if you're a company who's acquiring another company, just bringing them, just merging the two companies without taking into account information security considerations and risk management. We need to do that, and then certainly divestitures too. So these are just some vendor risk management considerations or third-party risk management considerations that we all kind of have to have some level of proficiency. And I think what they cover in the book is adequate, certainly for the exam. So I don't want to add too much to it, but I just kind of want to put them into context a little bit for you. Ethics. So we have the ISC squared code of ethics. Very, very testable. I would spend my time understanding these. The other ethics, knowing them at a high level is plenty fine. But this is one where I would spend time. Must be agreed upon before you become a CISSP. There's a preamble, canons, and guidance. Canons are mandatory. The guidance is advisory, meaning it's not mandatory. The canons are 4 of them listed here, and they're applied in order. So what you'll probably get in the exam is a scenario, and I can't think of one off the top of my head, but you'll get a scenario where you're going to have to break one of these canons at the expense of the other. So I can't think of a scenario. Maybe there's one in the book. So protecting society always comes first. So I might have to lie in order to protect society. That would be adequate. That would be okay. Because protecting society comes before. I wouldn't do either, right? But you'll get scenarios like that. So understand the order that they come in and understand the canons. You can get the latest copy from ISC Squared's website, but spend time understanding the ISC Squared Code of Ethics. That is very testable. It is an ISC Squared exam. Others, the Computer Ethics Institute has these 10 commandments around computer ethics. This is a little bit older. There's no enforcement of this. This is just their edict. So you have these 10 commandments. I'm not going to read them all for you, but you'll have them for reference. Internet Activities Board. So this one's a little bit older. When we get into more of the technical parts of security, we'll talk about what RFCs are. RFCs are requests for comments. They're really the documents that govern how the internet works. So all the protocols that you have that run on the internet, SMTP, FTP, TCP, all those things have RFCs associated with them. DNS has an RFC associated with it. IP addressing has an RFC associated with it. They're these things that are used to govern the internet. You can go look them all up too. They're all public. This is written into an RFC. In this case, it's 1087. It's older, 1987. And they just say these things are considered, essentially to be unethical behaviors. For those of you who are not ethical, certainly memorize them because you want to be ethical. But for the exam, knowing that there's an IAB ethics and that it's an RFC, that's probably fine for the exam. All right, governance. I like governance, but I'll have to go a little bit faster. So information security governance, these are the things that I would use. These are foundational documents typically that everything is going to be derived, that I do in information security is going to be derived from them. I have a kind of a rule of thumb for myself that if what I'm doing in information security doesn't find its root somewhere in policy, I don't have the authority to do it. So That's how I use policies, because policies are approved from the highest levels of management, ideally executive management. If I can get the CEO, that's awesome. But it's management giving me the authority to do these things that I intend to do in the environment to build a security program. Policies are mandatory. So things about policies that are really important is nobody reads policy. That's just the nature of the beast. So I don't write policies like books. I write policies like reference documents. It should be short, concise statements. Everything that I put in policy, I have the full intention of enforcing. Management needs to know that. If they're going to be in, they need to be in. So where there's non-compliance with my policies, there needs to be something happen. So policies are reference documents. They're kind of my Bible for information security. What else about policies? Short, concise statements, easily understood. You structure policies, and it's good that they mention this in the book. The program policy would be that sometimes we call this a charter policy, or it's the enterprise. If you look at the diagram there, it would be the enterprise information security policy. What typically goes into a program policy are roles and responsibilities for the information security program, maybe some definitions about security, maybe a waiver process goes in that policy. Things like that go there. They're high level, they apply to everybody. And then we have issue and topic specific policies. And if you look in the diagram there, you have a backup policy, a change control policy, data classification policy, so on and so forth. The reason why we create issue and topic specific policies to support that high level policy is if I'm a user and I want to reference these policies and I have a question about removable media, I can go directly to the removable media policy, which is usually 1 page long, quickly find what I need, and then comply. Versus I have a policy book that's 65 pages long, and somewhere in there it says something about removable media. It's not very referenceable and it's not usable. So that's why we break them out from program policies to issue specific policies. And then sometimes we also have system specific policies. These are policies that apply to a specific system within the environment, or a specific maybe environment. And there's actually another policy type. It's not in the book, but we do all have departmental policies too, a policy that applies to a department. So those are the policy types. They're very important. These are the things that give me all my authority as an information security officer. They're that important, and they're supposed to be that important. One other thing about policies is they need to reflect your culture. So taking a policy that I downloaded off the internet and then changing the name on it and expecting that to work, it's not going to work because it doesn't reflect my culture. It doesn't reflect how I do stuff. It may kind of the statements, but chances are you're going to have to make so many changes to it to kind of fit with everything else. Then policies are supported by other documents. So we have this high level stuff that goes in policy, and now we have to take it down to the ground level and actually put it into practice. That's where I have procedures, standards, guidelines, and baselines is kind of another funky thing. But procedures are step-by-step guidance. They're mandatory. So procedure, when I look at a procedural document, it should tell me how to get from point A to point B on a specific task, step by step. That's a good procedure. They're mandatory. Everybody's got to follow those. Standards are just specific uses of technology. They're not step by step. They're a little bit broader, but they apply to a specific technology. They're mandatory. Guidelines are recommendations. They're discretionary. It's advisory. I don't enforce guidelines. They're just kind of how you could comply with policy if you wanted. No, not if you wanted to. Here's one way you could comply with policy. And then baselines and benchmarks. In the book, it refers to CIS. The Centers for Internet Security is a great place to go get a bunch of benchmarks. But benchmarks really give you a method to implement a standard. So there's configuration baselines, configuration benchmarks, which would essentially be how I could implement the security controls in my environment to meet the standard. And that would be a baseline. Those are also discretionary. Personnel security considerations, security awareness and training. Those are two different things. Training is teaching you how to do a specific task or skill. Awareness is those ongoing reminders that should happen throughout the year. Kind of two different purposes. And people get really creative with awareness campaigns, which I think is awesome. Sometimes people hang them up in the urinal. I've seen that before. So when you go to the bathroom, there's your security reminders right there in front of you. Other people use posters. Some people put on events, whatever. A lot of different ways to do that. Other personnel security considerations, background checks. In most cases, it makes sense to do a background check. It'd be driven, if you look back here, there's a background check policy somewhere in this thing. Employee screening policy is where that would fit in this diagram. Criminal history, driving records, credit checks, employee verification, references. I've been through so many background checks because sometimes when you work for a company, you have to do a fingerprint FBI check or whatever. I mean, there's just so many different types of background checks that you could conduct. It really depends on the roles that people play in your organization. Some organizations just do one kind of background check approach for all employees. It's probably a good place to start, but as roles get more sensitive in your environment, you may want to implement more thorough checks. Most organizations do a one-time check and they don't do them on an ongoing basis. It's probably better to do it in an ongoing basis, certainly for those more sensitive roles. Terminations, formalized disciplinary process, progressive. So meaning that your first violation, it might be just a verbal warning. The next violation might be a written warning that goes in your employee record. The next violation might be whatever, and eventually it ends up in termination. Other things around employee terminations that I think are important to consider, and we'll go in deeper in all of this stuff later.
Yeah, can you unmute yours?
I didn't even join by sound.
I can hear you guys. Just kidding. I mean, I can, but exit interviews, rights revocation, account reviews. Account reviews are really that validation that the termination process worked as it was supposed to. Those are all considerations to take into account when you talk about information security governance and personnel security. Dealing with vendors, contractors, third parties, if they onboarded, formalized process, probably similar to but separate from how you handle employees. Then there's these concepts of outsourcing and offshoring. Outsourcing really is taking something that you used to do internally and outsourcing that to somebody else to do it for you now. There's a lot of security considerations around that. And then offshoring is kind of that same concept, but overseas. India is a real popular place for that. Crap, I'm not even going to make it. Sorry. Categories. So we've talked about access control, defensive categories, and types. Really testable. I've mentioned the categories before. This fits in our definition of information security. So administrative, technical, physical controls, or the order I used it in before was administrative, physical, and technical controls. Now there's different types of those controls, and this is testable. You will see exam questions about, giving you the context of a control. You have to take into account the context, because in one case it might be a preventative control, or it might be a detective control, and in another case it might be a deterrent control, or it might be both. So like if you take into account like a surveillance camera, if I just said, what type of control is a surveillance camera? Well, we know it's a physical, that would be the category, but it could be a detective control, or it could be a deterrent control. It kind of depends on how you're asking me, because it's a detective control because I may be watching the camera and I may detect something bad happening. So in that context, it'd be a detective control. But it might be a deterrent control because I usually make cameras visible. So if somebody's thinking about doing something bad at this site, they would see the camera and say, maybe I'll back off and go somewhere else. So these types are important. So preventative controls are used to prevent bad things from happening. That's their primary purpose. Detective controls, like intrusion detection system, would be a detective control. An intrusion prevention system would kind of straddle the line between prevention or preventative and detective. Corrective controls are used to used to correct a condition within the system. So there might be something that went wrong, but it's not, the scope is usually a little bit smaller in a corrective control. A recovery control would be to recover a system or set of systems. Recovery controls are usually a little bit larger in scope. You've got deterrent controls to deter something bad from happening. Then you've got compensating controls. You may have a primary control and then a control that's kind of used to add more strength to that primary control. That would be a compensating control. So spend time understanding, certainly spend time in the book and understanding these different types of controls and what context. You'll see exam questions on it, and you'll need to be able to determine that. Risk analysis, 6 minutes. All decisions should be driven by risk. That's why I gave you the definition of risk. It's another, I spent time today going over the definition of risk again. It's very important. It's definitely a cornerstone concept. Most people don't assess risk very well, formally or informally. I think we have preconceptions about what risk is, things that go into my risk valuation or calculation. Certainly the asset, you need to take into account the asset, because that's going to have a direct line to impact. If the asset's very, very valuable and something bad happens to it, well, then that usually would raise my impact a bit. Threats, I need to take into account threats. Threats compromise or take advantage of vulnerabilities, exploit vulnerabilities, which then leads to an impact. So I don't like the definition, the first one that's given in the book, that risk is threat times vulnerability, because I'm missing the impact piece. So later on in the book, impact was added. That's a better definition. So that's that. So threat and vulnerability, I think you need to combine those to create a likelihood of something bad happening. So vulnerability is nothing more than a weakness in the system. So you can put weakness in place of vulnerability. A missing patch would be a vulnerability because it's a weakness in the system. I need to take into account what threats apply to that weakness. And that should give me a good likelihood. But it also need to take into account the impact if that thing happens. So at the end of the day, we take threat, vulnerability, impact. I think that's a viable definition, and it's probably one that'll apply really well for the book. I'm sorry, for the exam. We have these calculations. Now these are also testable. I think you'll see them on the exam. Annualized loss expectancy, asset value exposure factor, single loss expectancy, and annualized rate of occurrence. Start with asset value. So determine what the value of the asset is. Now this is going to be a more quantitative risk analysis. Usually don't do this in real life. It's rare for us to go through this and calculate these numbers. But it does drive home the concept, I think, pretty well. So asset value, there's 3 different types of approach. The market approach, which is the market value for the asset. Income approach, how much income do I generate, or how much income can be attributed to this asset. And then the cost approach, the replacement cost. Whatever value you use one, pick one. But let's say, assign an asset value, and you'll see an example in the book. I have a question. If I'm using hard numbers, that would be a quantitative risk analysis. If I'm using that risk matrix you see on the right-hand side, that's an example of a qualitative risk analysis. So what makes quantitative and qualitative so much different? Quantitative is based on factual data, hard data. If I'm tying dollar amounts to it, that would be a quantitative risk analysis. Now you can't have, at the end of the day, you can't have a fully quantitative risk analysis in information security because there's not enough data to support it. So you always have some qualitativity to your risk analysis. And what it makes a qualitative risk analysis is, it's really based on a professional opinion. It's based on my best estimate. Some of it's factual. and where I'd use that risk analysis matrix. I'm assigning values that are more high, medium, low, critical, high, medium, low. I'm assigning values like that as opposed to hard dollar values. If I'm assigning hard dollar values, it's more quantitative. So it's a little bit, I look at the bottom right here on the screen, and that's qualitative. When I'm talking about ALE and asset value and all that stuff, that's more quantitative. So this is a calculation. So asset value, you take the asset value, multiply that by the exposure factor, and that's going to give you your single loss expectancy. So exposure factor is expressed as a percent of the asset that's exposed. So if I have a $1,000 asset and I have an exposure value of 80%, I come up with a single loss expectancy of $800, I think. I just did math in my head. So that's the single loss expectancy. Now, if I want to annualize that, I have to determine how often do I expect this thing to actually happen. That'd be my annualized rate of occurrence. To get my annualized loss expectancy, take the single loss expectancy and multiply that by how often I expect it to happen, the annualized annual rate of occurrence. So if I have a $1,000 asset, I'm just simplifying, if I had a $1,000 asset, and let's say I had an exposure factor of 50%, and I expect that thing to happen 3 times a year, whatever thing we're talking about. That's kind of crazy, because my asset value is 1,000. My exposure factor gives me a single loss expectancy of $500. I expect it to happen 3 times. I expect to lose $1,500 a year on a $1,000 asset. Now, if I have a control, it's only going to cost me $20, and it's going to bring that exposure factor down to 20%. You can start figuring out the math on whether or not there's a return on my investment. Sometimes we call that, I think it's on my next slide, we call that return on security investment. In the book, they call it total cost of ownership. So when I calculate the total cost of ownership, I calculate this annualized loss expectancy, and then I have to consider what the annual cost is of the control. Things that go into the cost of a control are the acquisition costs, the maintenance costs, licensing costs, personnel costs. All those things need to be brought into that equation to determine whether I have a positive or I have a negative total cost of ownership. Like I said, I think in the 20 plus years I've been in information security, I've done this calculation maybe 3 times. So it's real rare. Sometimes I suppose somebody wants it, so you would do it. But it does drive home, I think the value of, justifying your risks. One way you can do that. Budget and metrics, I'm a huge, one thing, having a separate information security budget is very important because I need to measure that against my metrics. So if I'm spending $10 million on information security and I'm not measuring my security program, I have no idea if what I'm doing is effective or not and whether I'm justifying my costs at all. So at least at a high level, tying your budget to specific metrics to determine whether or not you're making your security program better, whether you're using qualitative metrics or quantitative metrics, doesn't really matter. Measure something so that you can justify the costs. In most cases, when we bring risks to clients, their first reaction is, I need to mitigate this risk. I need to do something about it. That's not the case. We advise that, there's really 4 things you can do. There's a 5th, but the 5th one isn't a valid one. But one, I can accept the risk. Thank you for telling me. I know what the risk is. I'm going to accept it. That's a management decision. It's not a security decision. It's ideal if I document the risk acceptance criteria. So I have some criteria on why I make these decisions. I could mitigate the risk. That means I can put some controls in place to reduce the risk. I could transfer it. I could get some insurance, some cyber insurance, to push part of that risk to somebody else. I could avoid the risk, and that means I'm not doing whatever it is I was doing that led to the risk in the first place. I just stopped doing it. And then the 5th choice is called risk ignorance. So I just I ignore it. I deny it, and that does happen. So that's the only one that's not valid. But I don't think that one will be in the test either. All right, we're at 10:03. I don't know how many more slides I have left. Do we still have a bunch of people here? We still have 56. I'm going to try to go fast still until you guys yell at me. So risk analysis, I talked a little bit about qualitative and quantitative. Qualitative risk analysis is using qualitative data. It's not hard dollar amounts, not hard data. Qualitative, not using hard data. Quantitative is using dollars. It's using hard data. It's factual information. It's less opinion. That's the difference between the two. Most risk analysis, if not all of them that you do, will be qualitative, and that's okay. The risk management process, it's mentioned in the book. NIST is the National Institute of Standards and Technology. SP stands for Special Publication. 800-330 is a risk management process. This is just a reference. It's not one that you have to use. It's not one that I necessarily endorse either, but it outlines a 9-step process and how to do. They call it risk management. The problem I have with this one in calling it risk management is where's the loop back into the management process. So what we really have here is a risk analysis, starting with system characterization, going to threat identification. Those are the things that are going to compromise my vulnerabilities. So that's the next step, is determine what my vulnerabilities are, marry them together. That's the control, essentially the control analysis to come up with a likelihood determination. Then take impact into account. That's my risk determination. Control recommendation and results documentation. This is really how to do a risk assessment as opposed to really the risk management process, because the next step then would be roles and responsibilities for risk acceptance criteria, making those risk decisions, and then feeding that back into the process. So, but that's a good, I think, introduction to it. Oh, wow, I'm almost done. Wow, went through a lot of stuff today. Types of attackers, hackers, black hats, white hats, and gray hats. I call gray hats confused. They have identity crisis. They don't know what they are. One day they might be black, one day they might be white. It's kind of bad to be a gray hat, I think. So black hat, so hackers is one of those terms, I think it's just kind of thrown out there and it has a negative connotation to it. Purely, hackers really are people who use, kind of push the boundaries of systems, and they're not necessarily bad. The bad ones are the black hats. So the intention behind black hats is that, taking advantage of people. We lack ethics. We sometimes also refer to them as crackers or malicious hackers. Those are the black hats. Don't be a black hat. White hats are ethical hackers. We have rules. Now, one of the gaps that we have here is black hats don't play by rules. White hats play by rules. So when you're doing like penetration testing and you're doing hacking for hire, you kind of have to stop before you get to this point where a black hat would still keep going. So you kind of never get that true like black hat experience, but we have to stay that way. So white hats are ethical hackers. Those are the kinds of people that we employ. And then gray hats are, they might as well be black hats because you've compromised ethics, and I think you're kind of already there. But so I don't like the gray hat connotation. I think, if you're either black or you're white. The gray hats, one day I'm black, one day I'm white, you're black. Script kiddies. Script kiddies are low skill. They basically can click things and type stuff. They use tools and scripts made by other people. They're not very original. They're not hard to stop in most cases. They're just kind of disruptive, and they're just kind of annoying. It's like mosquitoes. It's not going to kill me. They just bug me. And that's kind of how script kiddies are. Outsiders versus insiders. So you have outside attacks and inside attacks. Obviously, they're much different. The attack vector. So attack vector is the method of attack. Honestly, in general, I think organizations do a fairly good job of protecting themselves against outside attacks. The weakness is on the inside, and outsiders will compromise that inside gooiness. And we don't monitor employees very well. I think just in general. So inside attacks can be very, very disruptive, and they can go on for years without anybody knowing. Usually outside attacks, it's kind of sad because I think I read recently that an outside attacker attacks within minutes, and it takes months normally to find them. But months is better than years usually in insiders. Other types of attacks, hacktivists, their motivation typically isn't money, it's notoriety for their cause. So they're, I think, more disruptive than anything else. They usually do things like website defacements, denial of service attacks, things like that. They generally don't steal data or information. However, they do that. They do occasionally do that also. Bots and botnets, these are disruptive usually. You can go and rent bots and botnets. You can go and buy 5,000, 10,000, 100,000 computers and rent them for X number of hours, days, and use those to attack others. So bots and botnets are pretty powerful because I can use those to send spam. I can use those to do denial of service attacks. I can use those for any number of other things. And then phishers and spear phishers. Phishing, everybody's seen phishing attacks, but to drive home the point that people are the biggest risk, we still consistently have 30, 40, 50, 60% success rates in our spear phishing attacks against our customers. I assume that attackers are getting at least that in their attacks. And so there's a really good return on your investment because a phishing attack is so easy to kick off and run. And what I get in return is credentials. I get real usernames and passwords. So it takes 10 minutes to send a good spear phishing attack, and I get, if I'm getting a 50% success rate, I hit, I'm targeting, say, 200 employees, I got 100 usernames and passwords. And some of those might be privileged accounts. So that leads to the next piece is if my remote access solution is single factor, it's just a username and password. Well, now I have a way into your environment. Now I got a foothold, and the next thing is for me to elevate my privileges, and the next thing is to plant something and come back later and then delete your logs. And it just kind of goes on. So phishing is a big piece that everybody knows about it. Everybody has seen it before, but it's still super, super effective, and attackers know that, and they're doing it. We've also have vishers, which is voicemail. There's text attacks. There's all kinds of other ones too, but for now, this is good. And then whalers or whaling, that's going after the big a CEO of an organization versus just a normal user. I'm going after a big target, and I'm usually very targeted at that big target, hoping for a big return. So those are types of attacks, and we'll hit on those more as we get through more stuff. Is a service like Cloudflare pretty good at mitigating distributed denial of service attacks? In my opinion, they're very effective. I've heard nothing but good things about them. So that's a good question. We made it. I'm only 11 minutes late at 12 now. That's not too bad. We made it. A lot of stuff. It's kind of a fire hose of information. The good thing is we don't have to meet again until Tuesday, so you have some days to kind of take it in and maybe read it again, whatever. Homework for Tuesday, it's going to be shorter, so it's not going to be such a, I'm not going to hit you with that much on Tuesday. We're going to go through asset security, protecting security of assets. So the homework is to maybe reread Chapter 2, read Chapter 3, 80 pages 81 to 98. That's only 17 pages. It's really short. I might go a little further in the instruction on Tuesday, but that's okay. We'll kind of feel it out. I don't want it to be so much like today where I have to kind of just slam through a bunch of information really quick. I want to take more time to get through it. I'm going to be sending a quiz. I haven't created it yet. I'm going to whip up a quiz, send that, make sure Rob gets that to everybody. And we'll have plenty of time next week to talk about questions too, because if you really are reading Chapter 2, I'm guessing there's going to be a lot of questions from it. And I look forward to getting those. So please bring those. Good. All right. Anything else? Let me know. Yeah, you'll be getting the quiz through email. We'll be sending that as well as the content for today. That's it. Have a great weekend. I really appreciate you guys. I don't get to meet you. I don't get to see you. I wish I did because, that makes it more fun. But I'm enjoying this. Hope you are. And hope we're good. So thank you. Have a good night.